Zimbabwe's controversial Constitution of Zimbabwe Amendment number 2 bill has been signed by the president and was published as an act on Friday. Opposition parties and many citizens have expressed outrage to the amendments that, amongst other things, sees the president retaining powers to decide his vice presidents and the power to appoint judges. The changes also scrap the 70-year age limit for sitting judges. The country's governing party ZANU-PF spokesperson Kennedy Mandaza spoke to me a little bit earlier today to explain why his party felt these amendments were necessary. The constitutional amendments, I believe, have been signed by the president. Why were they necessary to introduce these amendments?
Thank you so much, Peter. The amendments became necessary because as the government was aligning legislation with the Constitution, which is the supreme law of the country, it was identified that there were certain clauses and certain sections that needed to be improved, and some of them which needed to be corrected in order to ensure that they can meet the environment in which they will be exercised, and which so happens to be our country, Zimbabwe. So it is informed on the background that the country has been going through realignment of legislation subsequent to the change from the Lancaster House Constitution, and now trying to align policies and legislation in accordance with the Constitution that was passed in 2013. And as a result, they are certain, because it was a negotiated document, it needed to be improved in certain areas, and certain areas needed to be corrected. And that necessitated this amendment.
How is giving the president the power to appoint vice presidents improving the Constitution? When this Constitution was negotiated, the present system, where the president does the choosing of his vice president, they felt so strongly about it that they said, no, the vice presidents must be on an election ticket so that the people can vote for their vice presidents. But you're saying that, no, we want to keep the system as it is. You're going against the wishes of the people, are you not?
We are not going against the wishes of the people. As a party, even during the course of the constitution making process, we were very clear in terms of the running mate clause, but because we were negotiating with others who felt so strongly about it, like what happened during the Lancaster House Constitution, where we also our founding fathers also ceded to some of the things that ended up being in the Constitution, like the number of MPs that had to come from the former rulers, and the land question, the clause on the land issue. The same way is the same way how we ended up having the running mate, because we were negotiating, and we felt in order for us, for this constitution to move on, we needed to concede to some of the demands that were being made by those that were in the COPAC. You recall that it was not only ZANU-PF, there was MDC, there was also another party which was also represented, and all these came up with their views. But we were very clear, even during the course of the constitution making process, that the running mate is not in an indigenous kind of arrangement that we seek to have. And as a result, now that we have seen how we need to go with the constitution, we felt that this is the right time that we should bring it before Parliament, and Parliament will debate it. And it so happened that Parliament debated this issue of the running mate, and all of them agreed, 191, which is above the 2/3 that is required. But it is in no way giving the president uncheckered power, is what many people are saying. We are saying that the president, like what it was going to be happening, even when the running mate was going to, if it was going to be implemented, the president was going to nominate the one that he was going to run with. And why, therefore, not use the same kind of method of nominating the president, the vice president after elections have been done.
What about the issue of the High Court and Supreme Court judges, again, being promoted without having to go through second public hearings? Surely transparency is what the public would like so that they can have faith in the judiciary.
It's an academic kind of perception that when the judges interviewed in parliament or in a forum where they are interviewed, almost everyone sees that. And it is also not true that it is the public that interviews the judges. It is a selected group of people that have legal knowledge that we're supposed to do so. But we are saying, why, if we are taking people whom we know very well that they've been on the bench, they have been practicing for so many years, why then take them through this particular process of interviewing them when we really know that they have been exercising what their judiciary responsibilities, their responsibilities to the best of their abilities. And by virtue that it is not only the president who is going to say, so and so you are coming here, it is also the Judiciary Service Commission that is also going to recommend the people that the president will eventually appoint to be members of the bench. So we feel that we do not need to further embarrass the people by taking them to a public hearing, as it were, or public interviews as they were, because they say they are not necessarily the public, because it's not the public that interview them.
Yes, but they serve the public, and the public have a right to know who is representing them in the judiciary so that they have faith in them and faith in the judicial system. Surely transparency is a very important thing, and it happens all over the world.
Not necessarily, Peter, that it happens all over the world. There are certain jurisdictions in which what Zimbabwe is asking for is done. And one of them is where many people have quoted quite a number of times, where people think that these are the champions of democracy. The United States of America does not take their judges through the interviews. But here in South Africa, they do, and they have seen it fit to do so. And we are saying in our own terrain, in our jurisdiction, we need to ensure that on the recommendation of the Judiciary Service Commission and in consultation with the same organization, the president can then appoint the judges to the bench.
Legal experts say that these amendments may actually not even be legal. And if that's the case, are you not fearful that you're going to have the same issues you had in 2017 when the courts threw out these amendments? Are you not scared that this might happen again?
We are not scared. It is the responsibility of those who feel that the process that has been taken is not the right process to take it up with the courts. It is their responsibility, it is their right, and they can do so. And the courts will then make that determination. And if they win, it does not therefore mean that ZANU-PF or any of the people that were involved will be embarrassed. It means that we would have subjected what we are doing in the country through the courts. And if it so happens that the courts comes up with a certain decision that changes what we have done, so be it, we will take it up at that particular time. But we are quite confident that the process that the government, through its parliament, has gone through in making sure that these amendments are approved is the right process that should have been taken.
So the referendum was, the Constitution was approved by a referendum in 2013, and the people voted for the document that was before them. With these changes, they didn't vote for these changes. So are we not saying that they should be further consulted in one way or another before you make such profound changes?
It is true that consultations should take place. And it is true that the Constitution went through a referendum where 94.5 or so people voted out of the 3.3 million that went to the polls. But it is equally true that the people that were debating in parliament are people that were voted by the people that whom they serve. So they are the representatives, and one would therefore subsume that upon the reading of this particular bill in December 2019, the MPs should have gone to their constituencies to consult and get advice on what they need. And this is why we have members of parliament selected by people to go and represent them in parliament, so that whatever has to be approved, they can go first and consult the electorate who put them in parliament. And that process, one would want to believe that the members of parliament who were debating during the course before the voting took place, he had done their homework, consulting the people that they represent, and aid the views of the people who sent them to parliament.
Was it a surprise to see the number of MDCT senators that supported these amendments? Some would say this further cements the idea that a portion of the MDC opposition has been co-opted by ZANU-PF.
Whoever comes up with that, we do not have anything to do with what happens in the MDC. And the MDC is in their different variants or formats, whatever we might want to call them now. They are going through what they are going through right now. And whoever is in parliament right now is coming from MDC. ZANU-PF has nothing to do with the members of parliament that are coming from MDC. But one would also want to take from what the former prime minister, deputy prime minister said in the past, that during the constitution making process, even MDC themselves did not want this clause to be there, because they did not want Thokozani Kupe, who was the deputy president of MDC, to be appointed as the running mate. Hence, they accepted that it should take place after 10 years. So we are not surprised, because they never liked this particular clause also at the point when it was put in the constitution. But the question would be, why did they sneak it into the constitution making process when they did not want it as well?
All right, perhaps finally, a petition is being signed to protest against these constitutional amendments. If there's a sufficient number of people who say we don't want the changes, is this something that your government and your party is willing to listen to and perhaps pause?
The government that is being led by President Mnangagwa, and including the president himself, he has said many times that he is a listening president. If whatever the people say at the end of the day, if they are the people of Zimbabwe who are saying so, the president will listen. ZANU-PF will listen. So, but if whatever is coming up is not from the indigenous people of Zimbabwe, then obviously it will not be listened to. But obviously, the president of Zimbabwe, who happens to be the president of ZANU-PF, is a listening president, and ZANU-PF is listening to what people want. We will take up any issue that comes from the people of Zimbabwe.
Mr. Kennedy Mandaza, ZANU-PF spokesperson in South Africa, thanks very much indeed for your time. Thanks for joining us.
Thank you.